There you go. Okay. I want to thank Dr. Sperber for inviting me to participate in this conference. It's been fascinating to hear the speakers over the course of the day. And so it's wonderful to be here. What I'm going to present about is the modern Agunot problem comparing Israel and the diaspora. There are many people here who are experts in the various issues that I'm going to touch upon of the issue of Get Refusal in Israel. So I hope none of them will bite my head off for the ways that I present things. I'm not an expert in the issue in Israel, but what I can talk about is the issue in the United States. And as the director of ORA, the Organization for the Resolution of Agunot, I've been involved in this issue for about a decade. And so I think comparing this issue between the diaspora and Israel leads to some very interesting insights. I was even just sharing this presentation with some of my staff members yesterday, and even staff members who have been working in this area for years. Once you compare the two, Israel and diaspora, and how this issue is different, and how the responses are different, it's really quite fascinating. So I want to just tell you a bit about my organization, because I think that in and of itself reflects on the different type of approach that's taken in the United States. So ORA seeks to eliminate abuse from the Jewish divorce process, and we work within the parameters of Jewish law and civil law to advocate for the timely and unconditional issuance of a get. So some things about ORA. We're New York based, and we have 8 full-time staff members. We've assisted in the resolution since our founding in 2002 of 282 Agunah cases. And we're working on 70 active cases at any given time. Basically, the types of cases that we work on are cases that are anything but a strictly Israeli case. Meaning, if both parties are in Israel, we're not going to work on that case. But if it's a case in the United States, even a case we've dealt with cases in South America, in Europe, and certainly in Canada and Mexico as well, or cases that bridge Israel and Chutz La'aretz. So there's essentially this niche area of situations where, let's say it's an Israeli couple, and the husband flees Israel because there's a psak din against him, and he doesn't want to face the consequences of that, and he moves generally to one of 2 places, either Brooklyn or Los Angeles, so we will take on that type of case. So the wife is in Israel and the husband has fled Israel. Or the reverse, an American couple, let's say, where, as an example, the husband's not paying child support, he's going to be put in jail for not paying child support. So what does he do? He moves to Israel, right, to try and flee those responsibilities. So then we'll work on that case. We'll work on that case as well, which is bridging Israel and Chutz La'aretz. We receive, at this point, about 250 calls a year for assistance from almost all women, but some men as well, who are looking for assistance in the get and the bait-in process. And we have educational programming, educating about 4,000 students and community members every year about the issue of Agunot, domestic abuse, and the halachic prenuptial agreement. So let's talk about the power of the beit-in, comparing Israel and the diaspora. So number one, Israel, as we all know, has a state-sanctioned court system. It is an official system of the state, and rabbinical court judges must qualify and pass licensing exams, right? You have to be a rav in the rabbanut. Outside of Israel, the beit-in system is entirely unofficial and ad hoc. There are no official qualifications of rabbinical court judges. So any 3 Jewish men, they can call themselves rabbis. They can sit in Teaneck, New Jersey, or in Brooklyn, or what have you, in their backyard, and say, we're now a beit-in. This is our beit-in, and we're calling ourselves a beit-in. And they're just as much an official beit-in as any other beit-in that works on hundreds of get cases every single year. And this leads to a major challenge, which is in so many of our cases at ORA, is a situation where, let's say the wife wants to go to Beit-In A, let's say the Beit-In of America, affiliated with the Orthodox Union, Yeshiva University, the Rabbinical Council of America. It's probably the largest Beit-In outside of Israel. They facilitate hundreds of gittin every single year. The wife says, they have a good reputation, I want to go to the Beit-In of America. The husband says, well, I have 3 buddies who just declared their own Beit-In, and that's the beit-in I want to go to. And the wife is absolutely not going to the husband's beit-in. The husband doesn't want to go to the wife's beit-in either. He wants to use the get as leverage. And then you're just stuck. in this battle of jurisdiction between the Batei Din, which we'll get to a little bit. The legal enforcement power of the Beit Din in Israel. As we've been discussing, they can impose sanctions, enforce orders and penalties. They have the ability to incarcerate offenders when they do, if they do. That's a question we've been discussing. Whereas outside of Israel, the power of the Beit Din is limited to communal acceptance. The only difference between the Beit Din of America and the Beit Din of some guy, three guys in their backyard, is that the Beit Din of America is well regarded by the Orthodox community and certainly the modern Orthodox community in the United States. And so that's their only power, is that they have communal acceptance. If they say something, people say, oh, Beit Din of America, I've heard of them before, I respect what they have to say. But it's just about respect and acceptance. But there's no inherent legal enforcement power to the Beit Din outside of Israel. Then you think about issues of jurisdiction. So in Israel, geographical jurisdiction is defined. You have a Beit Din Ezori in Tel Aviv or Haifa, Tzfat, etc. And that is their jurisdiction. That's the area that they can rule in. And the battle of jurisdiction in Israel then becomes between the Beit Din and the civil courts. But in the United States, there's almost no Beit Din Kavua. And Beit Din Kavua this is the Beit Din of our community, and everyone who lives in this community has to accept the rulings of that Beit Din. Maybe Elizabeth, New Jersey is the only place where you have that, Rabbi Teitz, because he is the Mara Da'atra of Elizabeth. But otherwise, you don't have a Beit Din Kavua in almost any other place, certainly in the United States. And so then there becomes, as I was mentioning before, this battle of jurisdiction between Batei Din within the same area, where the wife wants to go to Beit Din A, husband wants to go to Beit Din B, and never the twain shall meet. And cases can stall for years and years and years just in this battle of jurisdiction. The husband is very fine. He's pleased with the stall in the process because all the pressure on the wife and it only continues to mount, and she feels time is going by without a get. He becomes entrenched in his recalcitrance, so that only works to his advantage. So what are the remedies that are used in these different jurisdictions? And again, based upon the different structures, that will impact the types of remedies that can be applied. So in the rabbinical courts, they will rule on the matter of the get, chiyuv get, kfiyah. They can impact the distribution of assets. If a case that I'm thinking of that we're dealing with, where the husband fled the jurisdiction of Israel, they issued a psak of kfiyah, and they said the wife should get all the financial assets because he wasn't supporting their children or anything along those lines. They can issue a detention order, tzav ikuv yitziyah. It's a question now. This has been an issue that's going on in some cases, or in one case in particular. Is that applicable to family members who are in Israel? Civil sanctions, as has been discussed, revoking licenses, freezing bank accounts. Now this new thing, which as was noted before, it's interesting that it's new, of harchakot de Rabbeinu Tam, of communal sanctions by the Rabbanut, and incarceration, as was discussed. In the diaspora, so what can the Beit Din do? The guy is refusing to give his wife a get. What can they do? By and large, the most that they will do is issue a seruv. A seruv is an order of contempt. He is mesarev lavo ladin. He refuses to come to Beit Din. Or there might be a situation where he's actually showed up and he's refused to listen to the ruling of the Beit Din. It will be a slightly different psak, lod sayat ladina, but essentially a seruv, holding the husband in contempt of the Beit Din. Very, very rarely is there a ruling on the matter of the get. In very few cases will a Beit Din in the United States say, this husband is chayav lagaresh. He is halachically required to give his wife a get. And certainly in terms of kfiyah, that almost never happens. So what will the Beit Din encourage? Communal sanctions, harchakot de Rabbeinu Tam, that the individual should be ostracized from the community, which will lead to public protests, communal pressure, which is very much the work of my organization. When we started off as just a group of college students. This was before my time, before I even got involved. It was a group of college students who would go around organizing peaceful demonstrations outside of the homes of recalcitrant husbands. And over the years, in the intervening 15 years, years, we've grown as a professional organization, and we've developed a more a broader toolbox in terms of the way that we approach these cases. So we always try to resolve the cases amicably by facilitating the beit-din process and doing anything we can to resolve the case by isolating the get from all other issues. If and when that doesn't work, we resort to using all forms of pressure which are permissible by halakha and civil law. So that includes the public protest, but at this point, that's a very small percentage of what we actually do. A lot of it is social pressure, public shaming, using social media to pressure the recalcitrant husband. If there are any legal tactics that we can take, we will do that as well. And so what beit-din will also do, as part of this seiruv, they essentially will issue a heter arkaot, a permission for the woman to pursue any remedies she can, limited as they may be, in the civil courts, and say, you've tried to work within the halachic system, you've tried to go to beit-din, now you can go to civil court, and if you can pursue any relief in the civil court, you're welcome to do so, and it won't cast any sort of cloud on the validity of the get. So now thinking on the civil side, so what can the civil courts do in Israel? And again, we'll have a chance to hear from Susan, who can speak with much better with expertise on the issue of nezikin and emotional distress claims. But that's one approach that's taken in the civil courts in Israel. Whereas in America, so what role can the civil courts play in America? There's a very limited applicability of emotional distress claims. We've looked into it extensively at ORA, done research in all 50 states, and what the standards are in applying, in suing for the intentional infliction of emotional distress, and the bar is very, very, very high to reach. And not only that, but because of the separation between church and state, between matters of religion and matters of the civil government in the United States, the courts, by and large, are very wary of getting involved in any sort of matters, any sort of entanglement in religious matters. So in one case, we were able to apply an emotional distress claim. That was in California, where the bar is much lower than in many other states. Some cases require to pursue a claim of nezikin, of emotional distress. The woman has to be hospitalized due to the trauma that she has suffered. Agunot don't go to the hospital because they've suffered that much. They've suffered in other ways, but it doesn't bring them to the hospital. So the applicability is limited. There are other the New York State get laws. And so there are two New York State get laws, and New York is the only state that has get laws. There was an attempt to pass a get law, I think in 2010, 2008, something like that, in Maryland, which did not pass. There was a recent attempt to pass one in Washington, D.C. That did not pass either. New York State is the only state that has get laws on the books. So the 1983 get law states that states that the civil divorce is contingent on the plaintiff, and I underline plaintiff, specifically the plaintiff removing barriers to remarriage. That's the language that they use. That the plaintiff is essentially turning to the court and saying, "Dear judge, I want you to grant me a civil divorce," and the judge is able to say, "I'm only willing to do that for you if you remove all barriers to remarriage for your spouse," and that's a nod and a wink to issue a get. So that's helpful to some degree when the husband is the plaintiff. But by and large, cases of get refusal are women who are victims of domestic abuse, because get refusal in and of itself is abusive, and it's often the last form of abuse which is exerted over the wife after a history of abuse, and that's why she left, because it was an abusive relationship. And so in situations of abuse, who's the one who's trying to get out of the marriage? The victim. The wife is the one who is the plaintiff in the civil divorce matter. So if she's the plaintiff, the New York State get law is not going to be helpful at all. In terms of the 1983 get law. The 1992 get law is a bit different. And whereas the 1983 get law was issued with full support of rabbis across the Orthodox spectrum, Moshe Feinstein wrote a tshuva on it, the Orthodox Union supported it, the 1992 get law it does not have that same rabbinic support, and there are some rabbis in Batei Din who say that if the 1992 get law is utilized in certain cases, the get is not a kosher get, another get has to be issued. And what it states is that in the division of assets and determination of spousal support and alimony and things like that, the judge can factor in the refusal of either party, either the plaintiff or the defendant, to remove barriers to remarriage. And so that has been used in some cases. I'll give you an example of a case where it was used, but the cases that I know of are the cases that have gone to ORA where it was ineffective. So one case, for example, where the wife worked for the state, for New York State, and she was entitled to a very large pension. And the couple had been married for well over a decade, and the ruling would have been that if the husband was entitled to about half of the wife's pension. And the judge used the New York State cat law and said, the husband's going to lose his rights to the half of her pension if he does not give her a get within 30 days. He didn't give her the get. He lost rights to the pension, and the civil divorce was finalized. Recently, there was the Masri case. This happened just about 2 months ago, where a judge in New York argued that and did not apply the New York State cat law to that specific case, and said that on constitutional grounds, its application is limited. So that's still cat laws of limited use. In some cases, they're helpful. In many cases, they're not. And it's like I said, only in New York State. So talk a little bit about advocacy in Israel and the diaspora. And I think this is also a really interesting distinction. That in Israel, you have this concept of toanot rabbaniyot, which is a relatively modern concept, and the advocates for Agunot are providing direct representation. They are attorneys. They are toanot who are representing clients in the Beit Din system. Where in the diaspora, whether my organization or you have the Boston Agunah Task Force, you have an organization in Los Angeles, you have an advocacy group in Toronto. These are social advocacy groups of groups that are raising awareness about this issue, not providing direct representation to the women in the Beit Din or in the civil court system. When you think about protest rallies, in Israel, to the best of my knowledge, and maybe Badia can correct me if I'm wrong, but protest rallies are outside of the Beit Din, right? Beit Din, why aren't you ruling in this way or that? Protest rallies in the diaspora, and certainly in the United States, never, ever happen outside the doors of the Beit Din. It's always focusing the attention on the home, on the recalcitrant husband. And then you think about political advocacy in a broader sense. In Israel, there's so much political advocacy to try and change the system, right? Change problems the structural issues within the Beit Din system through the political process. Whereas outside of Israel, that's just not the issue. And so the advocacy that's done is social advocacy to change communal attitudes and norms. Just show for you 2 pictures from protest rallies that we've had, just to give you a sense of what these look like. So in Brooklyn, we had about 100 people at that rally. I'll conclude with this, which just some interesting distinctions between Israel and the diaspora. First, talking about halachic prenuptial agreements, and I think, if anything, this highlights it more than anything else. The Haskem Lechavod Hadadi, which Rachel is going to talk about, is a halachic prenuptial agreement in Israel, and essentially what it's doing. There are many similarities with Beit Din of America's halachic prenup, but what it's doing in the large part is avoiding litigation in the Beit Din to induce the issuance of the get by avoiding having to litigate the issue in Beit Din. Whereas the Beit Din of America's halachic prenuptial agreement is exactly the opposite. It specifically empowers the Beit Din to be able to rule on the matter and sends the couple, both halachically and civilly, to be bound by the ruling of the Beit Din. It's a fundamentally different approach. We've been talking about statistics. In Israel, you have statistics. You have contested statistics based upon state records of divorce records. What you might want to call the Rabbanut versus the Rachman Center, right? You have Ruth Halpern Kadari's study that she did a few years ago, trying to count or assess the impact of get refusal on women in Israeli society. You have the Rabbanut statistics. Outside of Israel, what statistics do we have to try and put numbers on the Agunah problem? We don't at all. Because without an official registry of Jewish marriages and divorces, right, you can't know how many divorces are going on. If you can't know how many divorces are going on, you can't know how many contentious divorces are going on. So we really have no statistics on this issue. And finally, I'll conclude with this just as a little bit of a teaser, but I think it's really interesting, which is that when you think about progressive Piskei Din, you think of the get mitzvat, right? As it at least should be, that when a Beit Din rules on something and there's no appeal to the Beit Din Hagadol, that is the law of the land. Period. End of story. Close the book. When a Beit Din in Sfad or anywhere else issues a psak din, which is more progressive, or certainly the Beit Din Hagadol, that's it, and it's done, and it is published, and it's debated on merits. Whereas when you have a case of a heter that's applied for an Agunah outside of Israel, these progressive piskei din, they are accepted only to the extent that they garner rabbinic consensus, because you don't have an official system there. And so if a psak din is issued, it's only helpful for the woman if, practically speaking, this psak din enables her to remarry within her community or throughout the Jewish world. And that's only going to happen if there are enough rabbis with broad enough shoulders and significant credibility who have agreed to this psak din and have signed on. But what's interesting about it is that, unlike the process in Israel, the piskei din generally are not published and debated on their merits. It's a secretive process. The psak din is not shared publicly because concerns of privacy for the individuals involved and things like that. And it's just a matter of, these rabbis signed on. Do you accept it or don't you accept it? And that's the way that the process is initiated. So these are some of the comparisons that I wanted to share, just to give a different perspective on this discussion. I'm looking forward to hearing the other panelists present as well. Thank you so much.